Okay, I've seen James.
Yeah. Well, my lord. Good afternoon, my lord. Good afternoon, my lord.
Can you mute your eyes? Okay, it's okay. James, how are you?
Hi, my lord.
James.
My lord, good afternoon, my lord. Good afternoon, my lord.
Speaking. And I see him. And I see him. And I see him.
Can I see him?
I'm using my personal internet.
My lord, come on, my lord. Resume today, Wednesday, 17 November 2021. Before His Lordship, obviously, F.I. Case NICN BHC /50 2019 between Mr. Tony Momo and Cedarwood School Limited. A party outside, my lord.
Parties absent.
Yes, my lord. Party absent, my lord.
Council.
With respect, my lord. With respect, my lord. E.S. Dakari. Hello, my lord. E.S. Dakari.
Yes,
for the claimant, I appear with M. Dumoye.
with M what?
M. Dumoye. Dumoye. M as in Michael. M.
M-O-Dumoye.
Dumoye.
Respectfully, my lord. Respectfully, my lord. J.O. Osere for the defendant. Hello, my lord. J.O. Osere for the defendant. Hello. Hello? 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 Hello?
Cause judgment.
We start now, please.
Cancer,
Hello,
can
my
you
lord.
hear?
Did my lord hear my name?
I said, okay, you said your name is J.O. Osere. J.O. Osere for
Yes, my lord.
Yes,
my lord.
Miss or Mrs.
I'm Miss. Miss. Yes, my lord.
Okay, I want to read the judgment now. Can you hear me clearly?
Not clearly, but I can manage, my lord. I can manage.
Mr. Dakari.
My lord,
Mr. Dakari.
my lord, I can hear you, my lord. Yes, my lord. My lord, I can hear you.
Can we start the judgment now?
Yes, my lord. We can.
Can you hear me?
Yes, ma'am.
Mr.
Yes, my lord.
Dakari.
I'm
Yes,
hearing
We
you, my
can
lord.
hear you.
What of the defendant counsel?
Yes, my lord. I can hear you.
Okay, let's start.
Okay, let's start.
In order to save time, I'm going to read the issues
I'm going to
endorsed
use
on
as
the complaint.
endorsed on the complaint.
Issues
The issues as framed in the counsel's final written addresses.
And then I'll go to the decision part.
And then I'll go to the. I'm just leaving out the summaries of your pleadings and your arguments, but they are there in the judgment. So when you receive your copy of the judgment, you fill out the summary there. Are we good with that, please? Before I proceed.
As a couple, please.
As a court, please.
Judgment. On April 23, 2019,
Okay.
claimant filed his complaints against the defendant.
The claimant filed
For the following reviews.
and
1. The declaration that the defendant wrongfully terminated the claimant's employment with the defendant. 2. The declaration that the claimant, an employee of the defendant, Cedarwood Limited, is entitled to be paid his full salaries and other entitlements,
including maintaining the accommodation occupied by the claimant until his employment is lawfully terminated at the end of 2018 in August 2019 without forceful event in 3.
Another of this honorable court
directing the defendant
the claimant's salary for 1st of April
the defendant paid 2009
2019. Being the end of the
2019 at the rate of 540,057 naira 65 kobo per month. 4. Another of this honorable court directing the defendant to pay to the claimant the sum of 223,123 naira 33 kobo.
Being 126,017 naira unlawfully deducted from the claimant's January and 126,017 naira.
And 97,106 naira 33 kobo unlawfully deducted
January and March 2009 salaries respectively. 5.
from the
directing
5. Another than claimant is performance bonus since September 2018 till the claimant's employment is lawfully terminated. 6. Another of this honorable court directing the defendant pay the claimant the sum of 5 million naira representing cost of litigation, damages for unlawful termination and breach of claimant.
7. 10% of the judgment sum from the date of judgment to the sum is fully other initiating processes were filed
along with the complaint in line with the rules of this court. In response, the defendant entered appearance through the counsel and filed the statement of defense together with other defense processes in compliance with the rules of this court. The defendant also is counterclaiming the following. Is counterclaiming the following against the claimant. 1. Claimant. The declaration that the employment of the claimant having been terminated on the 26th March
2019, the claimant's right to use or be in
2020 possession of the two-bedroom flat
that
that was provided for
by
by the defendant counter claimant as equally been
terminated. Why is it echoing?
It's from maybe some of the forms. Maybe it's from the other people.
Two. A declaration that the claimant failure to relinquish possession of the two-bedroom flat occupied by him by reason of his employment as head of school of the counter another of the honorable court directing the court
claimant to vacate forthwith the two-bedroom occupied by him by reason of his employment in the counter claimant school, and having been terminated. 4.
Number 4. Another of these honorable court directing the claimant to pay to the counter claimant the sum of 67,000 naira, being the monthly prorated value of the two-bedroom flat, which occupied by him from the 30th April 2019, when the claimant was supposed to have vacated the two-bedroom flat as stated in his letter of termination, till whenever he vacates the said flat and delivers all possession.
Do you remember?
Recording in progress.
Where is the volume here? Increase the volume to the maximum.
Can you see me?
Huh? Where is my name? Okay. Name was here.
Progress. Progress.
But don't go. Don't go. It has to work less. Lana Cancer, can you hear me now? Can you hear me?
Yes, we can hear you, my lord.
Mr. Dakari?
Yes, my lord.
Okay, what of Mr. Where is the defendant counsel? Who is Ayodeji Adedipe? Defendant counsel. So can we continue now?
Yes, my lord.
Answer.
Yes, my lord, we can continue. Sorry, my lord.
Okay. In the final written address of the defendant, counsel to the defendant formulated these issues for determination of this court. 1, whether the claimant has proved his case on the preponderance of evidence so as to entitle him a relief being claimed before this honorable court. 2, whether the defendant counterclaimant has proved its counterclaim against the claimant on the preponderance of credible evidence so as to entitle it to the relief contained in its counterclaim. At page 220 of the court record is the claimant's final written address in which his counsel formulated the following issues for determination of the court. 1, whether the employment of the claimant was wrongfully terminated. 2, whether the claimant is entitled to be paid his salaries and other terminal benefits provided by the contract of parties from 26 March 2019 to March 2019. 3, whether in the circumstance of this case, the defendant lawfully deducted the sum of 223,123 naira 33 kobo from the claimant's salaries in January 2019 and March 2019. Whether the defendant's final written address is competent. Can you still hear me, counsel?
Yes, my lord.
Okay.
Yes, my lord.
Okay. I'm now going to the decision part. I'm going to the decision part of the judgment.
I have read the facts of this case and the arguments of their counsel. From all of this, I'm of the firm view that the following issues need to be resolved between the parties. One, is determination of the claimant's employment by the defendant wrongful? Is he entitled to payment of his salaries and other entitlements, including accommodation until end of August 2019? Two, is the deduction of total sum of 223,123 naira 33 kobo from the claimant's January and March 2019 salaries by the defendant proper? Is he entitled to payment of performance bonus from September 2018 till the determination of his employment? And is he entitled to the sum of 5 million naira as cost of litigation damages and for breach of contract of his employment? Is he entitled to 10% interest per annum on the judgment sum from the date of judgment till the sum is fully liquidated? And three, is the defendant entitled to its counterclaims? Before going to the merit of this case, let me make remark on the fourth issue raised by the claimant in his final written address. The issue is, quote, whether the defendant's final written address is competent, end of quote. At page 201 of the court record is the defendant's final written address, filed on March 17, 2020. When this process was brought to my notice in chambers, I saw that there were two names of counsel listed under the signature of the address, and the court is not sure of the identity or the particulars of the author. The particulars of the author of the address. This was pointed out to the defendant counsel at the subsequent sitting of the court after the filing of the address, and the court exercised its discretion and granted leave to the defendant to do the needful by refiling the address. In compliance with the direction, the defendant counsel refiled the address, which was received by the court registrar on July 13, 2021. See page 312 of the court record, with the author of the address properly indicated at page 319 of the record. With all of this fact before the court, I am of the considered view that making a pronouncement on the fourth issue of the claimant will amount to an academic exercise, which I decline from venturing into in this judgment, and I so hold. On the document containing the terms and conditions of the parties' employment relationship. In private employment relationship, otherwise known as master and servant relationship, like the instant case, the law is that the court first of all needs to examine what the terms and conditions of the relationship are between the parties, so as to resolve their rights, duties, and obligations. In doing this, the court is bound to look at the letter of employment of the claimant, any service regulations connected with the establishment of the employer, and the provisions of any statute, circulars, or other correspondence regulating the service condition of the employment. Two cases are cited there with their citations. Where parties have reduced the terms and conditions of service into an agreement, the condition must be observed. Both parties are in agreement that their employment relationship is regulated by the content of Exhibit C1, C2, and D2. See the defendant's response in its reply on point of law to the claimant's argument under issues 1 and 2, and the claimant's argument under issues 1 and 2. The terms and conditions of
the claimant's employment as stated in Exhibit C1, the letter of employment at pages 14 to 17 of the record. Also, Exhibit D2 is the defendant's staff handbook. See pages 70 to 151 of the court record. Furthermore, in Exhibit C2 at page 18 of the record, parties agreed inter alia that in the event that the school terminates the employment of the claimant before the end of the session, he will be paid for the period between the effective date of termination and the end of section, and that if the claimant resigns before the end of that section, he will pay the defendant his salaries for the remaining period of the section. It is my considered view that the clause referred to in Exhibit C2 is an amendment to the terms of the claimant's contract of employment in respect of the termination of his employment contained in Exhibit C1, and I so find. Therefore, I hold that this clause forms part of the terms and conditions of the parties' employment relationship. Consequently, I hold that the employment relationship between the parties is regulated by the content of Exhibit C1, the claimant letter of offer of employment, Exhibit C2, the email of January 19, 2019 from the defendant to the claimant, and Exhibit D2, the defendant's staff and now to the merit of the case. Is the termination of the claimant's employment wrongful? From the pleadings and evidence before the court, it is worthy of note that the claimant had earlier tendered this resignation letter dated January 20, 2019 to be effective from July 31, 2019, in accordance with the direction of the defendant in Exhibit C2 at page 18 of the record. See Exhibit C3 at page 20 of the court record for the resignation letter. However, on March 26, 2019, the claimant sent an email to the defendant sent an email to the claimant at 8:52 p.m. and terminated his employment with effect from end of March 2019, and that by the same email, the claimant was directed to vacate the accommodation given to him by virtue of his employment with the defendant by end of April 2019. See Exhibit C4 at page 21 of the record. In the claimant's letter of employment, Exhibit C1, at page 14 of the record, it is stated under the subtitle notice period. Thus, and I quote, should any party wish to terminate this employment contract during the probation period, a written notice of 1 month. Following your confirmation, however, a written one-time notice will be required by either party to terminate this contract. End of quotation. Furthermore, in the email sent to the claimant by the defendant on January 19, 2019, which is Exhibit C2, the defendant states, and I quote, as discussed today, the board of Cedarwood School has asked that you resign by the end of 2018-2019 session due to your below expectation performance and policy violation issues. In the event that you secure another job before the end of the section, you will be allowed to leave. However, you will be required to pay the school in lieu of not completing that section. The section. In the event that the school terminates your employment before the end of the section, you will be paid for the period between effective date of termination and end of session, end of quotation. From the content of Exhibit C1 and C2 before the court, it is my finding that whenever the employment of the claimant is to be terminated, either by resignation or termination, notice must be given to the other party or payment made in lieu of notice. In Exhibit C1, the notice is 1 month if the claimant is on probation, or a term notice if his employment is confirmed. In Exhibit C2, which I have found as an amendment to Exhibit C1, the claimant was directed to submit his letter of resignation by end of January 2019. Although it was to be effective by end of 2018-2019 academic section, which he did via Exhibit C3. That notwithstanding, the defendant still went ahead to terminate the claimant's employment with immediate effect on March 27, 2019 via Exhibit C4, dated March 26, 2019. It is my considered finding that terminating the claimant's employment with Exhibit C4 without notice is contrary to the terms and conditions of the claimant's employment stated in Exhibit C1 and C2 respectively. Consequently, I hold that the termination of the claimant's employment by the defendant is wrongful. I need counsel to respond. I need to, yes, you need to respond so that I will know you are following me. Do you hear counsel? Good, thank you.
Yes, ma'am.
Is the claimant entitled to payment of his salaries and other entitlements, including accommodation, until the end of August 2019? In Exhibit C2, the email of January 19, 2019 to the claimant, the parties agreed inter alia that, and I quote, in the event that the school terminates your employment before the end of the session, you will be paid for the period between the effective date of termination and end of section, end of quotation. The content of Exhibit C2, notwithstanding the defendant went ahead to terminate the employment of the claimant with immediate effect on March 27, 2019 through its email of March 26, 2019, Exhibit C4. It is my considered view that the defendant is bound by the agreement in Exhibit C2 reproduced above. And so I hold that the claimant whose employment was terminated with effect from March 27, 2019 is entitled to his salaries and other entitlements, including his accommodation up to the end of the 2018-2019 academic section of the defendant.
As a couple,
okay. When did the academic section of the defendant end in 2018-2019 section? In Exhibit C1, under the headings, quote, performance bonus, end of quote, at page 16 of the court record, it is stated in part, payment of bonus will be paid for a full section, in brackets, September to August, end of quotation. With this evidence before the court, I find I hold that the 2018/2019 academic section of the defendant started in September 2018 and ended in August 2019. Consequently, I hold that the claimant is entitled to payment of his salaries and other entitlements, including accommodation, until the end of August 2019, as agreed to by parties in Exhibit C1 before the in Exhibit C2 before the court. The claimant's salaries and allowances entitled to is with effect from 1st of April 2019 to end of August 2019, which is a total of 5 months.
As a couple,
Let's go.
Parties are in agreement that the last full monthly salary of the claimant while in the employment of the defendant was his February salary, his February 2019 salary, which is a total sum of 540,057 naira 33 kobo. Consequently, I hereby order the defendant to pay to the claimant a total sum of 2,700,286 naira 53 kobo as the claimant's salaries from April 1 to end of August 2019. Is the deduction of total sum of 223,123 naira 33 kobo from the claimant's January and March salaries by the defendant proper. Paragraph 4 of the claimant's relief endorsed on his complaint is for another refunding for another of refund of the sum of 223,123 naira 33 kobo wrongly deducted from his salaries. However, counsel to the defendant submitted in paragraph 1.03 of his reply on point of law that the action of the claimant in taking the school's cleaner home to clean his apartment constituted an act detrimental to the defendant's interest, contrary to paragraph N under the staff disciplinary action policy in Exhibit D2, and that when the claimant was punished for it by way of suspension, he did not challenge the punishment. To the defendant's counsel, the claimant, having not challenged his suspension when it was carried out, is stopped from doing so at this point, relying on the provisions of Section 169 of Evidence Act 2011 and the case of University of Calabar versus Isiaga, citation supplied. From the evidence before the court, the defendant made certain deductions from the claimant's salaries in January and March 2019, respectively. In proof of this, the claimant tendered and relied on his bank statement of account, Exhibit C5. It is at page 22 of the court's record. In this exhibit, the claimant was paid the sum of 414,040 naira 33 kobo on January 28th. On January 28, 2019, as that month's salary instead of the sum of 540,057 naira 65 kobo. See particularly page 23 of the court record. This means that the sum of 126,017 naira 32 kobo was deducted from the claimant January 2019 salary. The grant for suspending the claimant is that he violated the school policy. See Exhibit D5 at page 58 of the court record. An examination of Exhibit D2, the defendant's staff handbook, shows that the offense that the claimant was suspended for is not stated in Exhibit D2. There is also no other evidence before the court showing that the claimant's action amounts to an offense punishable by suspension without pay. As a matter of fact, the defendant witness, DW2, Henry Ikechukwu Ugoma, further cross-examination that the act of the claimant is not an offense under Exhibit D2. See page 11 of the proceedings file record recorded on July 2, 2019. Therefore, I find and hold that the suspension of the claimant without pay on a ground not contained in the terms and conditions of his employment and for which deduction was made from the claimant's salary is wrongful. I further hold that it is preposterous of counsel to rely on Section 169 of the Evidence Act 2011 and the case of University of Calabar versus Esiaga Supra, pleading estopel against the claimant to justify the defendant wrongful action in this circumstance. Again, in page 24 of the record, it is reflected in Exhibit C5 that the sum of 452,951 naira was paid to the claimant as that month's salary instead of the sum of 540,057 naira 65 kobo. This means that the sum of 87,107 naira 65 kobo was deducted from March 2009 salary of the claimant, and no explanation was given for this deduction as well by the defendant. Therefore, I hold that the defendant wrongfully deducted the sum of 87,106 naira 65 kobo from the claimant's March 2009 salary. From the foregoing, I hold that it is not proper for the defendant to deduct a total sum of 213,123 naira 97 kobo from the claimant's salaries in January and March 2019 without any justifiable reason. In addition, I hold that the claimant is entitled to the payment of the sum of to the payment of the total sum of 213,123 naira 97 kobo from the defendant as refund of the total sum wrongly deducted from his salaries for the months of January and March 2019.
As a court, please.
As court, please.
Is the claimant entitled to payment of performance bonus and the sum of 5 million naira as cost of litigation, damages, and for breach of contract of employment? In its release 5 and 6 endorsed on the complaint, the claimant is seeking for payment of performance bonus and for the sum of 5 million as cost of litigation, damages, and for breach of contract of employment. In Exhibit C1, under the heading performance bonus, it is stated, and I quote in part, you will be eligible to receive a percentage in brackets 0 to 10%, bracket close, of your annual salary as annual bonus depending on your performance against academic, administrative, and growth targets as set by the Board of Governors. End of quotation. The payment of performance bonus is conditional according to the terms and conditions of the claimant on the claimant's performance against academic, administrative, and growth target as set by the Board of Governors. However, in Exhibit C2, at page 18 of the court record, the Board of Governors of the defendant asked the claimant to resign by the end of 2018-2019 academic session due to his below expectation performance and policy violation issues. Also, in Exhibit C4, the claimant's employment was terminated by the defendant due to his non-performance. Due to his non-compliance with the terms of the contract. See page 21 of the record. Based on these findings on the claim, with respect to on the claimant's claim of performance bonus, I hold that the claimant is not entitled to performance bonus as he is rated performance at the material time does not justify that claim. Therefore, I decline from ordering the payment of the claim in the claimant's favor. Did you hear that, counsel? Okay. Additionally, with respect to the claimant's claim for 5 million as cost of litigation damages and for breach of contract of employment, Order 55 of the rules of this court, that's NIC and Civil Procedure Rules 2017, is instructive on issues of cost. This rule of court provides that in every suit, the cost of the whole suit and of each particular proceeding therein, and the cost of every proceedings in the court shall be at the discretion of the court as regards the person by whom they are to be paid. Therefore, this court will exercise its discretion on the cost of these all proceedings at the appropriate point in this judgment. With respect to the claimant's relief for damages and for breach of contract of employment, I find and hold that the claimant failed woefully to prove his entitlement to any money on this cause. In the circumstance, I decline from making any award as damages and for breach of contract in favor of the claimant in this judgment. Is the defendant entitled to its counterclaim? By way of reminder, the defendant in his counterclaim is seeking for a declaration that the employment of the claimant having been terminated on March 26, 2019, he has no right to use the 2-bedroom flat given to him by the defendant, and his continuous staying in the premises after his termination is unlawful and without basis. The defendant is also seeking for an order of the court directing the claimant to vacate the premises and to pay to the defendant the sum of 65,000 naira as rent on the apartment from April 30, 2019 until he vacates the flat. Counterclaim is otherwise known as a cross-action or counter-action. It is a separate and independent action by a defendant who has some reliefs against the claimant. Being a cross-action, the counterclaim is in the same position as an action, and it is guided by the same rules of the pleadings, as the burden of proof is on the counterclaimant in the same manner as it is required of a claimant in any civil action, which is on the preponderance of evidence. See Afolayan versus Ari G7, which is the rent receipt at page 88 of the record, is at page 68 of the record. It was issued on June 28, 2018 for a period of 1/7/2018 to 30/6/2019. The content of this document is contrary to the argument of the defendant counsel to the effect that the claimant refused to relinquish possession of the flat after the termination of his employment until the landlord of the house sued the defendant for possession and for payment of arrears of rent. Counsel then referred to this exhibit to support this argument. I have heard above in this judgment that the claimant is entitled to salaries from April 1 to the end of August 2019. I further heard above that the claimant is entitled to the use of the apartment given to him by the defendant up to end of August 2019, as agreed by both parties. Therefore, I hold on this issue that the defendant is not entitled to counterclaim against the defendant for the apartment in question or to seek for payment of any prorated rent from March to August 2019. Furthermore, there is no evidence before the court showing whether the claimant is still in the apartment or that he has left. If he has vacated the premises, did he vacate before or after August 2019? There is no evidence before the court supporting the fact that the school was sued for claim of possession and arrears of rent. The payment in Exhibit G7 was made in June 2018, almost 10 months before this action was commenced in April 2019. In the circumstance, I find and hold that the defendant has failed to prove its counterclaim as required by law, and this court is not ready to base its decision on speculations. Therefore, the entire counterclaims of the defendant lacks merit, and they are accordingly dismissed. On the whole, I hold, declare, and order. I hold that one. I hold and declare that the termination of the claimant's employment by the defendant is wrongful. Two, I hold and declare that the claimant is entitled to payment of his salaries and allowances from April 1 to end of August 2019. Three, I hold and declare that the claimant is entitled to enjoy his official accommodation with the defendant until end of August 2019. Four, I hold and declare that the deduction of a total sum of 213,007 kobo from the claimant's January 2009 salaries by the defendant is wrongful. Five, I hold and declare that the claimant is not entitled to payment of performance bonus from the defendant. Six, I hold and declare that the claimant is not entitled to any sum of money for as general damages and for breach of contract of employment. Seven, I hold and declare that the defendant is not entitled to its counterclaim. Eight, accordingly, I direct the defendant to pay to the claimant the sum of 2,700,286 naira 53 kobo as his salaries from April 1 to end of August 2019. Nine, I hereby direct the defendant to pay to the claimant the sum of 213,123 naira 97 kobo as the sum of money wrongly deducted by the defendant from his salaries. 10, I hereby direct that the judgment sum of 2,700,286 naira 53 kobo plus the sum of 213,123 naira 97 kobo, which is a total sum of 2,913,410 naira 62 kobo, only shall be paid by the defendant to the claimant within 30 days from today. 11, thereafter, the judgment sum shall begin to attract 10% interest per annum until judgment sum is liquidated. And 11, the defendant is to pay to the claimant the sum of 500,000 naira
as cause. Judgment is entered accordingly, and that is the end of the judgment.
As the court, please.
As a court, please. My Lord, we are very grateful for this considered judgment and the patience that the court had to go through, not minding the challenges of our times. We are very grateful, my Lord.
That's Mr. Dakari.
Yes, my Lord.
Ms. Osere. Defendant counsel. Osere Jennifer. Council can come and pick their judgment next week, like I think Tuesday, because I'm not on ground in Port Harcourt now. By God's grace, I'll be returning over the weekend. Then I can print. I'll print the copies, and then you can pick it on Tuesday by God's grace.
As a court, please. Thank you, my Lord.
That's the end of the session.
Thank you, my Lord.
Yeah.